It's good morning to everybody. Welcome to the today class of the Muslim Club, which is the review classes, which I promise that I'm going to deal with question by after one question, and this is the one for one of the questions which I want to deal today. And please read what I cited on the screen, so that I could know that you are hearing me and I am hearing you. Yes, Sikandar, please unmute and read what I cited on the screen so that I could get an answer from you. Yes, please.
Good morning, sir.
Very, very morning. That means you are hearing me and I am hearing you.
Yes, sir. Exactly, sir.
Very good. So this is a good morning. That there will be three VDC students and who are the Muslims? Can you give me the answer? Who are the Muslims? Yes. Any idea?
Sir,
Any idea? Who are the Muslims?
Muslims are the Islamic followers, sir.
Yes, it's nothing but Muslims are the people who are the professors that believe in Islam, and as a believer they worship the one God and revere the Prophet Muhammad, the peace be upon him, as the last messenger of the God. Additionally, they also believe in all the prophets which have preceded Prophet Muhammad, peace be upon him, and the holy books which they brought, such as the Psalms, Torah, and Injil, and Gospel. The fundamental article of the faith of Islam is belief in the day of judgment, when all the humanity will be recompensated with their deeds in the world. Muslims believe in the angels as well as in the predestination. So that is about the Muslim and Muslim around the world. Of course, this is there. And is there any distance between the Islam and Muslim? The answer is Islam cannot be judged based on the action of the Muslims. Islam, the perfected religion of God, is entirely separate from the imperfect human who are themselves Muslims. So Muslims are different and Islam is different in one way in another way. A person who follows the Islam, they are said to be the Muslims, but Islam is not a Muslim. Islam is a perfect later submission to God. That is actually the translation, that is the Arabic term. As in the other religious bodies, they are the practicing and not practicing Muslims, liberal Muslims and conservative Muslims, tolerant Muslims and extremist Muslims. However, their individual actions should not be used to scrutinize or label Islam. In fact, it must be mentioned here that the media stereotype Muslims is far from the reality. The vast majority of the Muslims in the world are indeed peace-loving human beings, with many of them striving hard to live up to the great ideals of Islam. The why I am giving this thing, suppose if they ask the question, the distinction between the Islam and Muslims, at the time they will not be confused. That's my point. And today question which I made, which I said already, that is the unit 3, that is the what is question number 5, what is parentage, legitimacy and acknowledgement under the Muslim law with examples and decided cases. That is the expected questions out of 10. I am dealing with this one. So now, without wasting the time, let me pounce upon the thing. What is the actually the parentage? Parentage in the sense, yes. Anybody, can you make it? What is meant by parentage? What did you understand? Just for a rough idea for me. Yes, anyone? Yes, rough idea for me that what is parentage. Yes, unmute and give me the answer. If you don't know this, you say the pass on so that I could continue without wasting the time.
Sir, please continue, sir.
Yes, sir. So that is the best method. So the parentage in the sense, parentage is the relations of the parents and to their children. That is the parentage. It is a relation between the children and the parent. That is called the parentage. The parentage includes, there are two parentages there. One is maternity, another is paternity. And the maternity is the legal relationship between the mother and the child. That is the maternity. And the paternity is the legal relationship between the father and the child. That is the paternity. So, we do have the paternity leave as well as the maternity leave. Is it not? Say yes, at least. Okay. Parentage is generally used for a legal relationship with the child has with the parents. So that is the relationship between the child and the parent is called the parentage. These legal relationships are associated with the certain rights and duties such as the right of inheritance, maintenance, and guardianship. These are the generally the rights which the parentage relationship between the child and the parent will be there. There is the inheritance, there is the maintenance, and again the guardianship is there. How paternity is established in the Muslim law? How do you say that he is the father of the so and so child? So paternity of the child can only be established by marriage between his or her parents. So his or her parent means her parent means either wife or uh, the husband. That's why reason they say his or her parents. The marriage may be valid rather and be regular, be irregular. So it should be valid and should be, of course, even irregular marriage also can become a regular because the irregularity will be diminished. Then it becomes a regular marriage, but it does not become a void marriage. So if it is irregular, it doesn't matter. If it is valid, it is a very valid good because we can say is the parentage. And but for void marriages, we cannot say the parentage because the children's born to them is extramarital children, or we can say, in other words, the illegitimate child. So paternity is established in the husband of the mothers of the child. So how the paternity will be established? In the husband of the mothers of the child, by the paternity will be established. So paternity is established in a person said to be the father by proof or a legal presumption that the child was begotten by him on a woman who was at the time of the conception his lawful wife and is in good faith and reasonably believed him to be such or whose marriage being valid. So we can say the parentage at that instance only when the child was conceived to a woman and the woman is the valid wife of the husband. So at the time of the conception, his lawful wife in since illegally wedded wife, and within good faith and reasonably believed by him to be such or whose marriage being valid. So both of them should believe that the marriage is a valid marriage, and if it is a irregular marriage, also doesn't matter because the irregularity will be removed over there. Then the marriage becomes a valid marriage, but it will not be applicable to the void marriages. So let us come to that. An issue of a void marriage has neither the paternity nor the maternity under Shiala. But in the Sunni law, there is an exemption to be there. Suppose the father will not be known over there, but the mother will be known because the mother is given the birth to the child. At the times, a son will or a daughter will inherit. Then that means child will inherit from the mother because mother is known to them, because father is unknown to them. So, but in an issue of the void marriages is there, neither the maternity or the maternity, neither the paternity nor the maternity under the Shiala. So, Shiala will not recognize either the maternity or paternity for which the child is a illegitimate child. But whereas comes to the matter of the Sunni law is concerned, yes, paternity will not be known over there, but maternity will be recognized because the mother has given the child and the child is born to the mother. At that instance, only the child will inherit from the mother but not from the father. So that is the difference that you will find it between the Shia and Sunni law. I am sure that you are following me. If the answer is yes, please say yes. At least say yes so that I can proceed. Say yes.
Yes, yes, sir.
Very good, very good. That you the sense that you are following me and I am with you and you are with me. So now mute,
Yes,
now
sir.
mute, now mute, now mute. See, once they you have given the answer to my question, then everybody should have to mute. Otherwise, your background will be heard by me. Yes. How maternity is established in Muslim law? So there is no difficult task for the maternity because a mother is given the birth. Definitely, the child is the child is the legitimate mother. We can say that because the mother will be known over there by the child, and child will be known by the mother because mother gives the delivery to the child. So under the Sunni law, the maternity of the child is established in the woman who gives the birth to the child, irrespective of whether the birth was the result of the valid marriage or adultery. Here, adultery in the sense, in the Arabic terms, will say zina. So, what is zina? Zina is an Islamic law concerning the unlawful sexual relations between the male and the female who are not married to one another through a nikah. That is the ceremony. It includes extramarital sex and premarital sex. It is an extramarital sex as well as a premarital sex. It also includes the adultery, that is the consensual sexual relationship outside the marriage. So that is the zina. If the child is born with the zina or out of the zina, at the time son, mother only the maternity would be there, but the paternity will not be known because it is only the mother knows who is the father of the child. Do you agree? Do you agree? Say yes or
Yes,
no.
sir. Yes, sir.
Good, very good. But under the Shia law, only birth is not sufficient to establish maternity. It has to be also proved that the birth was the result of the lawful marriage. But the Sunni law, the birth is given, it is enough. The child will inherit from the mother. But in the Shia law, the birth is itself is not the show the maternity, and it should be there. Is the result of the lawful marriage. That should be another condition in the Shia law. So we can say under the Sunni law, an illegitimate child or illegitimate child can also be called as the extramarital child, and his maternity in the woman who gave the birth, and the child is entitled to inherit from the mother alone, but not the father in the Sunni law. But what about the Shia law? Neither from the father nor from the mother the child will be inherit because the child is a extramarital child or illegitimate child. So that is the law. So, but under the Shia law, an illegitimate child has neither the maternity in the woman who gave birth nor paternity in the father. So, in Shia law, the illegitimate child can inherit neither from the father nor from the mother. In other words, illegitimate child could not inherit anything from the mother or father. So, what is the legitimacy in Muslim law? Let us see that. A person born in the lawful marriage is said to be the legitimate child of the spouses. So, the main point is in the case of the legitimacy of the child, is the marriage between his or her parents should be a valid marriage. Of course, the irregular marriage also can be made because irregular marriage can become irregular when the irregularity will be removed over there. So that is the point, but for not the white marriages. So special notes regarding the presumption of legitimacy. How do you make the legitimacy? The presumption would be there. Number one, a child born within the 6 months after the marriage. After the marriage, if the child is born within 6 months, the child is illegitimate unless the father acknowledges the child. The child is becomes illegitimate within the 6 months is born over there. Unless if the father say no, he's the conception is with me only and I am the father of the child, then only the child becomes a valid, a legitimate child. Number two, a child born after the 6 months from the date of the marriage is presumed to be the legitimate. So after the marriage band, if the child is born after the 6 months, yes, it is presumed that the child is a legitimate child. Number third, a child born after the dissolution of marriage is legitimate. Of course, the dissolution marriage is there, and after the dissolution of marriage, the child is born under Shia law if born within 10 months. If the 10 months within 10 months from the dissolution of marriage, if they born over there under Shia law, they say that they are a legitimate child. But Hanafi law, if born within 2 years, practically it is impossible. We cannot say that within 2 years of the dissolution of marriage, because the conception will not take place over there. Conception will take within the period of the 9 months only. It will be known whether the conception is there or conceived is there or not. So it's a practically impossible over there for the Hanafila, but theoretically we have to read that it is the 2 years from the dissolution of marriage. If the child is born over there, then we can presume that is a legitimate child. But under the Shafi'i and Maliki law, if the born within the 4 years, practically impossible it is also. If the after the dissolution of marriage, I said. The 4 years also they say that it is legitimate, but it is practically impossible. That's why I told you that in Muslim law, some of the places we will see the practicality, and in some of the places we say that whether practical, feasible or not. Like I told you already that a Muslim can marry the four at a time. So is it practicable now at this juncture in the digital India? Anyone give the question on just academic debate. It's not a partiality. The answer is no. It is only the theoretically, but practically none. So let us see the legitimacy of when conclusively presumed under the Indian Evidence Act. So how do you make it Indian Evidence Act? I will say 1872, a child is presumed to be the legitimate. So section 112, that is 112 of the Indian Evidence Act. If a child is born during the marriage, of course, it is valid within 280 days. That is nothing but 9 months. After the dissolution of marriage is well and good. A child shall be presumed to be the legitimate child of the spouses. So practically, for the purpose of this, whether the child is a legitimate or not, we will rely on the section 112 irrespective of the caste and creed and religion. So the Indian Evidence Act supersedes the rule of Muslim law. Answer is yes, it's true. Because practically, impractically also will seen over there with that irrational man definitely will make it out. This is the practicable, this is not practicable. So the Muslim law is overruled by the Indian Evidence Act 112. The question arises whether the provision of the Indian Evidence Act supersedes the provision of the Muslim law. The opinion are divided, but the balance of the authority remains the favor of the Indian Evidence Act. Naturally, a prudent man definitely will make it out. 112 would be applicable over there if the child is born after the dissolution of marriage within the 280 days. At the time, the child will be presumed to be the legitimate child. Yes, the Muslim law statement provisions which are impossible for the practical reasons because the Indian Evidence Acts come to the rescue in such a situation. Yes, a prudent man definitely will take the point and will see. There is also qiyas, also the consensus of the mind, also that we study in the source of Muslim law. At the time, yes, it will be taken into consideration where the majority of the people will give that is the right, then generally it will be accepted the right. because the majority will not be wrong. Of course, majority people are the prudent persons, not the insane persons. I think that you are following me. Yes. If the answer is yes, please say yes. Unmute and yes, and you
Yes,
say
sir.
very good. Then mute it immediately. So, what are the conditions for the valid acknowledgement in the paternity under the Muslim law? So, let us see the what are the valid conditions should be there where you can say the acknowledgement of the paternity under the Muslim law. So, let us see the acknowledgement of the paternity is a part of the substantial Muslim law. This must be made according to the provisions of the pure Muslim law. The following conditions are the necessary for the valid acknowledgement. From this point of view, law may be either substantial or procedural. The substantial law is that which defines the rights, and while procedural law it defines the remedies and the procedures. That, as you know, that what is the distinction between substantial law and the procedural law. Let us see the what is the paternity. The conditions should be there in the substantial law. A child, number one, a child acknowledged must not be offspring of illicit intercourse. Yes, that whenever you want to make an acknowledgement, it should not be very much clear. It should not be very much clear that the child is born out of the wedlock in the sense without the tying of the marriage, that it's called zina. So that illicit intercourse is called zina. Zina, zina. The sexual intercourse, the BBC between the child mothers and the acknowledger must not be unlawful at the time when the child was possibly bare, conceived or born. This is to say the child's mother was not within the prohibited relationship. Again, what are the relationship there where you can say that is a prohibited relationship? And what are the things are there? Yeah, that yes, it is jumped, I believe. How maternity is established in the Muslim law. Yeah, coming to, yeah. Number one is the child born after the 6 months. Oh, very good. Just it is jumped. The concept is jumped over there. Just a minute, because yeah, how maternity is established in the Muslim law that they merely said there should not be a zina, and that the child born within 6 months of the marriage of the child illegitimate unless the father acknowledges the child. Of course, we are ready, and conclusive Indian Evidence Act also we read it. Then we are the conditions are valid. This is the paternity that we are going to make it out. Yes, a child should not be born with the conceived with the zina. The relationship between the mother and father should be a valid one. Then only we can consider the child is a legitimate child. The child's mother should also not be a triple, irrevocably divorced wife of the acknowledger himself at the time when the child would have been begotten, when the legal bar of the remarriage was to be removed. So after the triple talaq, also if the child has conceived over there, even though that is also we cannot claim it is the paternity at the time, because at the time of the conceiving, she is conceived with the illegitimate with a valid marriage. In short, a lawful marriage between the child mother and the acknowledgement must be have been possible under the Muslim law. When the child was conceived or took birth in such a marriage was not possible, there can be no acknowledgement will be there. So what I want to say is that when the acknowledgement of the father wants to make it out, at the time, the conceiving of the mother would be a valid wife first. So when this valid wife only that there, we can say that if the acknowledgement will be possible, the paternity will be possible. But if it is very known that the child is born not conceived by this person, it is conceived by illegitimate intercourse with the zina, at that time acknowledgement will not come into the rescue. So that is the first point. The second point is the paternity of the child must be uncertain before the acknowledgement. So the paternity of the child, who is the father, who is the mother? Of course, mother easily I can make it out because mother is conceived and she is pregnant. And with that one can say that she is the pregnant woman. Yes, the paternity of the child must be uncertain before the acknowledgement. That is to say, the child must not be of the offspring of any other unknown person. So it should not be very much clear that this woman has conceived because of this also man. So that is the reason if it is known in such a way at the time acknowledgement will not be possible. If it is provided that some other person is the father of the child, yes. If it is clearly made, no, this father, the fellow is not the father of the child, but she is conceived because that fellow is the father of the child at the time, the mother is with that fellow. The acknowledgement cannot be accepted as his own child. So whose father is unknown to the person when the acknowledger wants to make it out. But if it is specifically known that so and so person is the father of the child, at the time the acknowledger cannot make the acknowledgement, and that is not about the paternity, acknowledgement of the paternity. That is the second condition. The third condition is that there must be such difference in the respective age of the acknowledger and the child, which conforms to a father and relationship. Whenever the person is acknowledged over there, he cannot acknowledge that a adopted or acknowledged baby should be 18 years old. No, not 18 years old. He should be a suckling baby, preferably. If the acknowledger is equal in the age or is younger, neither the equal nor the younger to the acknowledged person, the acknowledgement of the paternity would be void. And it is very fast because they would not appear to be the father and child. So whenever the person wants to be acknowledged over there, there will be a long difference. Difference should be there between the father and the acknowledged and acknowledgement. So that is the thing which is made it over there. But that is the preferably will say the suckling baby means unweaned baby only would be acknowledged by the father, but not the 18 years boy will be acknowledged by the father, stating that he is my son. Or like the equal range or the younger to the child would not be acknowledged over there. So naturally, in another sense, that a suckling baby or unweaned baby will be acknowledged. So according to the Bailey, the acknowledgement must be at least 12 and a half years older than the person acknowledged. So whenever a person is father is acknowledging another child, at that time, at least the difference between the age group of the acknowledged and the acknowledged should be 2.5 years difference should be there. At least that is the Bailey says so. So that is the third condition. The fourth condition is the acknowledgement of the paternity by a person must not only be an acceptance of the child as his son or daughter, it should also be the effect that he has accepted the child as a legitimate child for all the purposes, including the inheritance. So merely the way orally with the saying the acknowledge the child is not enough, but you should have to there the intention that yes, he acknowledged and treated the son or daughter, whoever it may be. You should be also the effect that he has accepted the child as a legitimate child and for all the purposes including the inheritance. So mere intention is not enough, but intention to the other act, furtherance to it also will be counted. That only then we can say it's an acknowledgement. So Muslim law recognizes acknowledgement as a method where by such marriage and legitimate descent can be established as a matter of the substantial for the law for the purpose of the inheritance. Yes, because of the inheritance, they want to make it out the substantial law would be there, where that all the conditions required for the acknowledgement should be fulfilled over there. By whom? By whom? Yes, anyone can unmute and give the reply.
Father, sir.
Father means he can the acknowledger.
Yes, sir.
Acknowledger means acknowledged means the child. So Muslim law recognizes the acknowledgement as the method where such a marriage and a legitimate descent can be established as a matter of the substantial law for the purpose of the inheritance. So let us see the one of the case law in the case of the Muhammad Allah, the Khan versus Muhammad Ismail Khan. This is the one of the case law in 1887. Justice Mahmood held that where the marriage cannot be proved by direct evidence and no legitimacy is be established. Number one, what is the condition? That marriage is not directly proved over there. Then number two, no legitimacy is established. Muslim law prescribes as a means whereby the marriage and a legitimacy must be established as a matter of the substantial law, and that the acknowledgement of the paternity is must. Then only the child is a valid child, not valid child, legitimate child. Otherwise, the child will be treated as a extramarital child. So acknowledgement under Muslim law is a rule of substantial law and not a rule of evidence. It is not a rule of evidence, it is a rule of substantial law. Clearly, it means it is not a presumption under the Evidence Act. There is no presumption would be there. It is a substantial law where the four conditions should be fulfilled over there. Whenever the acknowledger wants to acknowledge a person for the legitimacy by the following the four conditions. There must be a clear intention on the part of the acknowledger that he has not only accepted to become a father of the child, but also accepted the child as a legitimate issue. Yes, he is only that the Telugu saying that కడుపులో లేని కవరించుకుంటూ వస్తుందా నో కడుపులో కూడా ఉండాలా కవరించుకోవాలా both things should be there. So casual love or affection towards the child is not sufficient to confirm the legitimacy of the child. So casualty just for the sake of the others, if you make an acknowledgement that is not set with the acknowledgement, because the intention should be very much clear. On somewhere in some place, it should be made very much clear that after my death, this property goes to my son and to whom I acknowledge. So if there is a documentary proof would be there that give the sense that he has an intention to give the property after his death to his son in the form of a will. I am speaking. Of course, the inheritance definitely will become as per the personal law. In the case of the Muhammad Ali Khan versus Muhammad Ibrahim Khan, 1929, that the Privy Council, the father made the acknowledgement of the child in a casual manner. If you make the child in a casual manner, he never intended that the acknowledgement should have a serious effect. It was held by the Privy Council that the act of the father is not sufficient to confer the state of legitimacy. Because merely for the namesake, if you could make the acknowledgement without any having any intention, at that point, the court will presume that mere making such a statement is not enough, but it goes with the intention to do so. Then only it is a valid acknowledgement. Under the Muslim law, there is a provision that the acknowledged child has an option to repudiate the acknowledgement upon attaining the age of the discretion and understanding. Suppose the acknowledged, after attaining the majority, yes, he have the every right to repudiate such an acknowledgement, because he said, I am no more a child of yours. Yes. So he can liberate himself or herself. The acknowledgement of the paternity is therefore not valid where such a child has repudiated the acknowledgement on attaining the discretion. Suppose after the age of the 18 years, or he or she make that, I am no more a child of you, then the acknowledgement not a valid acknowledgement. So repudiation of the father-child relations by the child negatives the acknowledgement of the paternity. So how the repudiation will take place with the father and child? The father and child, the repudiation will take place when the child, after becoming a major, and the negative that the acknowledgement of the paternity, yes, it is the repudiation of the would be effective. For a valid acknowledgement, it is necessary that the acknowledgement child has not repudiated. So, if you want to make the acknowledgement should be a valid acknowledgement at the time when the child has reached the majority at the time, he should not repudiate it. Then only the repudiation, then only the paternity is said to be the valid or the acknowledgement is valid. VALID. Yes, I'm sure that you are following me what I am. Yes, say yes. Okay, okay, no matter. Acknowledgement of the paternity is irrevocable. So once the acknowledgement is made, he cannot revoke it. That's why we say irrevocable. A valid acknowledgement of the paternity once made cannot be revoked by the acknowledger. A complete and valid acknowledgement is therefore irrevocable, at any subsequent reactions or denial by the acknowledger cannot affect the legitimacy of the child or acknowledged. Once they say acknowledged, it is irrevocable because it is like a arrow coming out of a bow. It cannot be go back. That is the same thing. It is irrevocable. So let us see the legal effect of the acknowledgement of paternity. Yes, what is the legal effect of the paternity? Let us see that. What the legal effect of the valid acknowledgement of paternity may be summarized as under. Number one, the child so acknowledged becomes a legitimate issue of the acknowledger and its paternity is established. So it is very much clear that he is a child and he will be, in all means that he will be entitled for the inheritance or all other legal rights will be falls on him because not only the merely his orally that he did it, but his intention to do so also is made. So that is the valid effect would be there for the paternity. Number two, as a legitimate issue, a child is entitled to inherit the properties of the acknowledger, its mother and other relations. Yes, definitely he acknowledges that he is the father here, and if he acknowledges or there paternity over there, then naturally the legitimate issue, the child will be inherited from the father, even for the mother or even for the other relations also because the acknowledgement is a valid acknowledgement and the paternity is a valid paternity. Number third, acknowledgement of a child paternity is also established a lawful marriage between the child's mothers and the acknowledged. Once the acknowledgement is made it over there, it gives the clear sense even the child's mother also is a valid wife. So that is the same thing which is shown in the section, sorry, in the serial number 3. Acknowledgement of the child paternity also establishes the lawful marriage between the child's mother and the acknowledger. The child's mother gets the status of the wife and that to be a valid wife and a legal wedded wife of the acknowledger, the person who acknowledges means father, and she too is entitled to inherit the property of her husband, that is the acknowledger. So now let us see the judicial decisions, some of them. In the case of Mehboob Nisa Begum versus Muhammad Yusuf AR 1950, Hyderabad 41, it was observed that the person must acknowledge the child is his son. So whenever the person is acknowledged over there, the child should be son, both orally as well as from bottom of the heart. It must be shown that the person making such acknowledgement intended to confer the status of legitimacy on the child. Yes, merely the oral is not enough. There should be a intended legitimacy also is going to confer to the child. That is also a very important factor. So let us see the legitimacy in the status, which results from the certain facts. While legitimation is a proceeding and which creates the status of legitimacy and which did not exist before, there is no legitimation in Muslim law. See, legitimation is different and the legitimacy is different. So there is no legitimation in the Muslim law. A child to be the legitimate must be conceived during the marriage of a man and his wife, and any other child is offspring of the zina. That is, I already told you what is zina. Illicit connection between the cannot become illegitimate even by the subsequent marriage of his parents was observed in the case of Habib Rahman versus Altaf Ali. Suppose if a person has born or conceived in the zina without a marriage, but later if they married, so illegal not become illegal, or that is clearly mentioned in the Habib Rahman versus Altaf Ali, AR 1922 PC 159. Suppose we had only one BBC would be there without conceiving. Of course, after that they married over there. Then the child will be conceived after the marriage when the BBC was there, and after the marriage and the social recognition at the time definitely at the time of the conceiving they are the both are wedded wife and marriage. At that instance, it is a legitimate child we can say. Yes, in the case of the Rashid Ahmad versus Anisa Khatun, that year 1932, the Privy Council 25, a child will be a product of zina. If the child is a product of zina, that is illegitimate intercourse and can't be legitimate by the acknowledgement, where it is proved that the mother was the married wife of another at the date of conception. Suppose if it is proved that at the time of the conception she is already married to another person, but everybody knows that he is the father of the child at that instance, the acknowledged person cannot say that he is my child because everybody knows that the child conceived to that mother is belongs to some other person. So an acknowledgement of the paternity need not be expressed. The acknowledgement of the paternity is not expressed, and such an acknowledgement may be presumed, and from the fact that one person has habitually and openly treated another as a legitimate child. As observed in the pre-council in the case of the Muhammad Azmat versus Lali Begum 1881, the PC, that is the Privy Council held, it has been decided in several cases that there need not be a proof of an express acknowledgement, but that the acknowledgement of the children by Muhammadan as sons may be inferred from his having openly treated them as a son. Suppose if the implied acknowledgement and expressed acknowledgement, if the implied acknowledgement gives the clear sense at that instance, we need not to prove that because the act itself shows he is not only the orally that he is acknowledged, but he has did it with intentionally and he put it in a white and black also to give the inheritance to the child. Or whatever, what are the difference between the present law prevailing in India and Muslim law when it comes to the legitimate of the child? So in India, the legitimate of the child determined as per the section 112 of the Indian Evidence Act 1872 for all children, both non-Muslims or Muslims, and the two major differences are here. As per the Muslim law, the child must be conceived in a valid marriage. As per the Evidence Act, the child is legitimate as long as he is born in a legal marriage. I repeat, as per the Muslim law, the child must be conceived in a valid marriage. As per the Evidence Act, the child is legitimate as long as he is born in a legal marriage. That is within 280 days, and the legal marriage should be there. A child born for up to 280 days is legitimate according to the Evidence Act, that is section 112, that is 112. The difference in Muslim law, because the different school of Muslim law is mentioned different figures. Under Shia law, if born within 10 months, and the Hanafi law is born 2 years, and Shafi'i Maliki law, they born 4 years, which is practically not feasible over there. Hence, the Muslim law is eclipsed by the Indian Evidence Act 18. Section 112 will prevail over there. So this is the today's class, and thank you very much for your patience listening. And if you want to ask anything, you can ask me, because I wish that you should have to get good marks in your exam. The exam will be the evening, and the questions for tomorrow class also. Will like to deal it, because this is a thank you which I am going to show you, and the tomorrow class that with the same timings 9:15 that I will like to do it. That is two questions. Yes, today that I dealt the question number 4. Yes, no. Question number unit 3, question number 5. That is what is the parentage and legislative acknowledgement and the Muslim law, the example and disregard. Unit 3. Then you can see the question 6. Please read. Anyone unmute and read. What is the question 6? Because I can share the screen to you. Please unmute and read.
What is the meaning of guardianship, and discuss the kinds of guardianship and how renewal resolve
Removal.
removal of the guardianship under personal laws.
Yes, this is the thing which I want to give to tomorrow at the 9:15. Is it no 9:30? Because that's the time which I fixed over there as usual. So tomorrow class is the question number 6. We will do it. And if you want to say anything, you can say, please. If not, say
No
thank you
problem.
very much.
Thank you,
Let
sir.
us meet tomorrow. Yeah, this is the thing which I want to make it out. And now stop sharing. Thank you very much for the patient listening. As my policy is that even one person also there, I will like to deal my class, because I will not. My food will not be digested if I don't take any class. That is my